Hi there, this is Jonathan Ginsberg, and this is a video I'm preparing for my clients post-hearing. These are cases where you're going to be approved. And so, of course, first of all, I would tell you congratulations. Obviously, we've talked about it after the hearing, but it's not easy to win disability these days, so congratulations on your win. Of course, you want to know what's going to happen next, and that's what I want to tell you. So first of all, what's going to happen is the judge will issue a written decision, and that decision should say fully favorable decision, notice of decision, fully favorable. It comes in the mail. I get a copy, you get a copy. Comes in the mail in about anywhere from 2 to 6 weeks, and there's really no control we have over that. The way decision making works is that the judge writes out his decision, checks off some boxes and makes some notes. Then they send it to a writer, somebody who was not at the hearing, and it's back at the office. That person writes it up into the form of a written decision. Judge has to approve it, and then they mail it out. Judges try to get these things out quickly because they know people are real anxious. Sometimes it can be 2 or 3 weeks, sometimes it can be 6 or 8 weeks. So they don't want you calling Social Security. What I do is if I haven't heard anything in 2 to 3, I'd say 2.5 months, I'll start calling, but I don't like to bug the judges, but it's going to take a little while. So assume it's going to be a month or more to get that written favorable decision. Once we get the decision, I would urge you to read it. I read them to make sure that the information contained therein is the same as my notes when it comes to the onset date, when it comes to other information, because again, I want to make sure that if for some reason there's a problem down the road, that we have an accurate written decision. Once the decision's issued, then you'll start getting a series of letters. If your case is disability or SSDI only, it'll come from Social Security Disability, where they'll tell you, that they've reviewed the file and that this is how much you're going to be paid, this is when your payments are going to start, and sometimes it'll say how much you're going to get. They'll talk about the attorney's fees. Typically they approve my fee agreement. What they'll do is they'll withhold 25% of the past due benefit, but they'll send me, on a fee agreement case, they'll send me $6,000. So sometimes people get confused because it says we're withholding $25,000, but they only pay $6,000. So any questions about that, of course, call my office. But in a fee agreement case, which is most of the cases I take, it's going to be at most $6,000. Even though they withhold more, they will actually send you the difference. They will only send me $6,000. So, but again, questions about that, let me know. If it's an SSI case or there's SSI involved, there'll be a whole nother series of letters that can get very confusing because the SSDI will offset the SSI. So you may see an approval note from SSI, then the next day a denial notice from SSI. Again, we can answer those questions, but bottom line is that if there's SSI involved, you'll probably have to go through an income and resource interview because SSI is a welfare program. And basically the income and resource interview will determine how much offset from your SSI benefit will be in your case. And so then these letters start coming, I'd say a week or two after the decision. Then it may take another 20 to 30 days before the first check comes. Typically, the lump sum will be deposited, and then after that, the monthly checks will come. They don't do checks anymore, by the way. It'll be done either as a debit card or directly into your bank account. If it's directly into your bank account, make sure that you segregate that account with your bank so that it's a sub-account of your main bank account, or that only Social Security money is going in. The reason for that is if you have other money going into an account with Social Security, then somebody should sue you, try to garnish or levy on that account. You could lose your Social Security money. It's hard to get it back. But if the account is your bank knows this is only Social Security money, then you won't ever lose it because it is, other than for child support and taxes, SSDI money will never be taken. No judgment creditor, no credit card company can ever get it. SSI money, which again is welfare money, nobody can get it. Child support, taxes, nobody can get it. So it's really important to make sure that your account is segregated as a sub-account or as a separate account with your bank, and that they know that they should not honor any kind of judgments or any kind of levies on that account because this money is by statute is protected. So that's kind of what you need to know about the next process, about that process after that. I want you to also be aware that under the current environment, you can expect your case to be reviewed in a year or two. That means you got to continue going to the doctor. That means you've got to keep being compliant with medical treatment, with diet, with medicines, and so forth. And be aware that a continuing disability review is something that we're going to start seeing more of, because Social Security is running out of money. They're looking for ways to get people off the system. And I will tell you that continuing review is one where people call me about them sometimes, and since there's no back benefits, I have to charge for them. So you're looking at, $3,000, $3,000. So again, if you think that your case is one that might be reviewed, it might not be a bad idea to set aside some money that you might need to pay an attorney to defend you if Social Security tries to cut you off. And hopefully that won't be the case, but I think the days when Social Security money, once you got on Social Security, you're on forever, I think those days are coming to a close. So be aware of that. And finally, I would ask you, if you were happy with the work that we did in my office, myself and my staff, that you give us a favorable review. There's some links here to a site on a page on one of my sites where you can give me a review. It's very helpful to me. It lets other people know that I work hard on behalf of my clients, my staff works hard. And it helps my search engine positioning and so forth. So if you're inclined and you've got a couple minutes, I would really appreciate it if you would give me a favorable review, positive review. Let me know what you think. If there's something you weren't happy with, let me know that as well. Let me know that personally. Just send me an email on that one, and we'll try to make it right. So again, we work real hard on behalf of our clients. We believe in our clients. We think that the disability process is legitimate for those who are truly disabled and cannot work, and we fight real hard for them. And again, if you've been happy, please let us know. So that's it for the post-hearing kind of checklist. Any questions, let me know, let my staff know. We're happy to help you, happy to answer those questions. We're here for you after the case is over. Even if you need something a year from now, 2 years from now, call us. We keep our files electronically. So if you need your records, for example, if you want your records, let us know. We'll get you your records back. Afterwards, we can get them electronically. So again, we're here for you, and we hope that you'll consider us to be your lawyers, and anything you need in the future, you'll let us know. So that's it for right now. Again, Jonathan Ginsberg here, and again, congratulations on your victory, and hopefully it'll be smooth sailing from here on out, but regardless, either way, we are here for you. Until next time, I will talk to you soon.